It's a long time since we are rejoining, so I will try to pick up the thread from where I had left. I think on the last occasion we had spoken about the basic structure. We had also spoken about Keshavananda Bharati and its impact, and we were moving in a progression towards Maneka Gandhi. There is a particular reason why we are trying to move towards Maneka Gandhi, because Maneka Gandhi is the culmination of various concepts which will be, of course, available in terms of a challenge. Whenever a challenge is placed, these are parameters which will be important for you people to understand. So, therefore, I am taking it in a progression towards Maneka Gandhi. I had on the last occasion also spoken about a situation which had happened in relation to ADM Jabalpur's matter. In the ADM Jabalpur's case, I had talked about Justice Khanna's dissent, which is also otherwise known as the habeas corpus cases thereafter. And we had also, to a certain extent, dwelt with the political scenario at that point of time. Because the whole conspectus of individual rights has to be seen against the backdrop of state action. I had emphasized on this that whenever there is a majority in parliament and a majoritarian government, meaning whereby that they have a huge majority by which there is no check and balance in relation to the legislative actions which they can take. And of course, those legislative actions thereafter translate into executive actions. This kind of a scenario invariably leads to a transgression of individual rights. And it is these kind of scenarios which threw up a situation like this, which brought about judgments around that time. So I had spoken about the political scenario at that point of time when the emergency provisions were invoked, where Mrs. Gandhi and the Congress had an overwhelming majority at that point of time in the legislature. Now, immediately post emergency as well, what had happened was that the Congress, when it was in power at that point of time in 1976, because the judgment in Keshavananda Bharati had been rendered during the coup around that period, just prior to that, and Keshavananda Bharati essentially had more or less given every concession which the Parliament wanted at that point of time, wherein it also said that as far as an amendment is concerned, the aspect of Article 13, that aspect would not be attracted as far as a constitutional amendment is concerned. And it had also gone to the extent of saying that even fundamental rights were subject to amendment. But however, it had preserved the basic tenets of a democratic republic by saying this, that the essential features and the basic feature of the constitution is not subject to amendment. So that was the saving grace. And since basic features were not defined into any four corners, it left scope for interpretation thereafter. So therefore, it will be a little interesting to see as to what happened and how things took a different turn. Because in 1976, the Congress at that point of time came up with a very infamous or a famous amendment called the 42nd Amendment. Now, this 42nd Amendment came because an attempt before that was made to somewhat change the basic structure doctrine by applying for a review in the Supreme Court. And interestingly, the basic structure aspect, when it was brought before the Supreme Court had constituted a constitutional bench of the same strength of around 13 judges to look into that aspect. Luckily for Indian democracy, if I could say that, the judges came to an opinion that this could not have been an issue which should have been raised, for which a constitution bench should have been constituted. And the Chief Justice Ray, at that point of time, subsequently decided to dissolve the bench. So that challenge to the basic structure was staved off. When we talk about that, you must bear in mind that for a constitution bench to be constituted, there is a minimum number which is envisaged. The minimum number which is envisaged for a constitution bench is provided for in Article 145 of the Constitution, which says that any constitutional challenge will not be heard by a bench which is less than 5 judges in number. So what constitutes a constitution bench in the Supreme Court will be a bench which will comprise of 5 or more. Since it was a 13 judges bench, it was also a constitution bench, because the number was more or less the same as was delivered in the Keshananda Bharati case, the same strength. Now, having said that, so when this challenge in a way failed, the powers that be came up with what was known as the 42nd Amendment. Now, this 42nd Amendment was a very different kind of an amendment, because it was a kind of an all-embracing kind of an amendment which came, which more or less tried to undo everything that had happened till this point of time. What it did, it brought an amendment in 31C, Article 31C of the Constitution. And in that amendment, interestingly, there was a dimension which was introduced by stating this, that any such law which would be brought in with an object of enforcing directive principles of state policy or furthering the directive principles of state policy will not be subject to question before any court of law. Now, this was a very pernicious way, because all that the executive or all that the legislature had to do, whether the center or the state, was to enact a law which would say that the purpose was to enforce, the purpose was to further the object of directive principles of state policy. And the same law, even if it deprived fundamental rights or did away with Part 3, would not be subject to any scrutiny by any court. So, this was one aspect. In the same breath, it also brought in, by way of this amendment, a scenario which said that all amendments which have been done till this point of time and amendments which will be done henceforth using constituent powers of the legislature will not be subject to any court, any scrutiny by any court, High Court or the Supreme Court. And this also related to all amendments which had been brought till date, starting from 1950 onwards. So essentially saying that everything that had been laid by the Supreme Court till that point of time would be rendered to naught. So you see what a majoritarian government, a majoritarian legislature, where it commands absolute majority or a majority which is substantive in nature, what it can do if there is no check and balance. Now, when this happened, then came this historic case at that point of time, which is now known as the Minerva Mills case, where this 42nd Amendment was challenged. And luckily for us, the Supreme Court examined the constitutionality and struck down the 42nd Amendment more or less wholesale. Though, of course, with this also came a rider, and the rider was this, that it said that directive principles of state policy in chapter 4 and fundamental rights in chapter 3, these are like two wheels of a chariot. So the attempt should be to harmoniously construct the two. It should not be that the directive principles of state policy undermines fundamental rights, or in the enforcement of fundamental rights, directive principles of state policy are given a go away with. So any law which is enacted which will disturb this balance of this chariot will essentially be in derogation of the basic features of the Constitution. So therefore, the aspect of directive principles of state policy being the object to be attained, and in a way the fundamental rights being the means by which it is to be obtained, saw a kind of voice in this judgment for the first time. Though the court disagreed with this, that it will not be subject to judicial scrutiny, but the court to that extent travelled to say that these two will have to be seen at the time of a constitutional challenge as to where they stand. So with Minerva Mills, a little shift from the situation happened. The basic structure started getting a kind of a color. The basic structure which was spoken of at that point of time, where major things I had said, like the concept of judicial review, I had spoken about the fact that division of powers, these and many other features, slowly and steadily over a period of time, the court started evolving. Now, for instance, in this, it said that these two fundamental rights and directive principles of state policy in together happen to be a part of the basic structure. Now, having said this, before I move into Maneka Gandhi, there is one small judgment which comes in between, and that is by the name of Royappa. Royappa versus State of Tamil Nadu. Now, in Royappa's case, Royappa was a very interesting kind of a situation, which this kind of a scenario you normally see in relation to the powers that be. Royappa was the Chief Secretary of the State of Tamil Nadu at that point of time. Now, when he was the Chief Secretary, he fell in disfavor with the incumbent Chief Minister. So what does the incumbent Chief Minister do? How to do away with a person with whom you don't see eye to eye? So what the government did at that point of time was to create another post. A post which was essentially not having the same kind of attributes and the same kind of responsibilities and the same kind of, you could say, power structure which went along with the post of a Chief Secretary, and relegated him to that post by way of a deputation. An ornamental kind of a post which had nothing to do, like he had no powers or he had no responsibilities as such. So when this happened, he placed a challenge saying this, that he was being discriminated against, and the court was asked to look into this. This matter went up to the Supreme Court. The Supreme Court looked into it, though did not agree with him. But one interesting thing happened in this case. And the interesting thing that happened in this case was that the court, while discussing all this, came to the view, brought in the element of Article 14. And it dilated on the aspect of Article 14, which we will find a relevance later on when I talk about Maneka Gandhi, wherein the court said that Article 14 is an article, 14 to 16 for that matter, are articles which strike against, they relate to equality, and they strike against arbitrariness. They also, at that point of time, Justice Bhagavati came with a paragraph in that judgment, which later on was then thereafter subject to interpretations and came with further improvisations by the time of Menaka Gandhi, wherein Justice Bhagavati stated for the first time that one, equality and arbitrariness are sworn enemies of each other. 14 to 16 attacks that arbitrariness. It relates to equality. Equality and arbitrariness are sworn enemies of each other. And as far as equality is concerned, equality essentially belongs to the domain of rule of law in a republic. Try and understand. Rule of law in a republic. And as far as arbitrariness is concerned, he said that arbitrariness relates to a domain which is essentially the domain of, it relates to unfairness and it relates to a domain of a monarch. In a monarchy, because a king can do whatever he feels like, so it relates to that capriciousness which you can associate with the domain of a monarch. So he made this kind of a comparison. And he also said that any act of the state, in a way, needs to be seen from this touchstone of Article 14 to 16. So, in a way, the aspect of arbitrariness was looked into. Now, this is a very interesting development in relation to what I am going to say hereafter. Because, in a way, this particular concept of arbitrariness, thereafter, you will find it being displayed in relation to the Maneka Gandhi's case. And how it is expanding and bringing into Article 21 a concept which was debated and not agreed upon at the time of the Constituent Assembly debate. And that interesting concept is the one from where, because at the time when I had started the initial lecture, I had said that from the Japanese Constitution, which came into force a year before, was imported Article 21. More or less, it's a complete lift from there. And the variance between that, a constitution of Japan which was written by the occupational forces, which happened to be also America at that point of time, wherein the due process clause was changed to procedure established by law. So Article 21, the form and substance in which you see it today, that no one shall be deprived of his right and personal liberty except by the procedure established by law. This is an entire lift from the Japanese Constitution. Article 31 of the Japanese Constitution as such was taken in after a debate at the Constituent Assembly, wherein they decided that the due process clause of the US Constitution will not be taken in because it will spell a lot of trouble. Because of the simple reason that, if you remember what I had stated, that we cannot trust the judges. And after all, the elected representatives who find themselves in parliament, they are the persons in whom this power should be vested as to what kind of laws they should make and what kind of laws they should not make. And everything cannot be left in the hands of a few judges who are not elected but selected, and who will determine the law, those aspects of law in a challenge. So the due process was debated that this was something which would bring in a lot of challenges before the concerned court. So now what was said in Royappa will slowly translate in Maneka Gandhi, wherein the court then further expands this power and expands it to an extent that the due process of law, that aspect of the American Constitution, will now find a reflection. So now, before we go into that, we need to just, for a little understanding, try and decipher what is this due process of law and how is it different to a certain extent from procedure established by law. What do you understand by the due process of law? As I'm just trying to, because it is a huge kind of development which comes through various judgments in the American Constitution, how it finds its interpretation by American courts. Various judgments are there. The Lochner's case is there. Then you have the Maryland case. So I'm not going into all those discussions, but I'm just trying to cull out so that it will be a little easier for you to understand. The due process, as contemplated, has got two elements to it. One is the substantive due process, what they call as the substantive due process. And the second element is the procedural due process. Now, as understood in the American jurisprudence, if I could say, the substantive process is the why element. How and why, these are two things, two dimensions. So when the question is asked why a particular law, right, then it is the substantive process which is being brought into operation. When the court questions why this law, whether this law is just, why this law has been created, and whether this law which has been brought in is reasonable and just, when it asks these questions in relation to the said law, it is the substantive process of the substantive part of due process, that element which is coming into play. Whereas when it is asking the question how the procedure is being brought into effect, then it is going into the procedural aspect of due process. So broadly speaking, these are the how and why questions. The why question will relate to substantive, and the how question will relate to the procedural part. To illustrate by way of an example, let me take an example to try and illustrate this. Now, for example, in the state of Delhi, there is a law which is brought into force by the Kejriwal government by saying this, that drunken driving will be prohibited. You drink and drive, you will be arrested. Now, this aspect of arrest, when arrest happens, your personal liberty is put to peril. You are deprived of your personal liberty. So when it goes into whether there is a process which is there by which you have to be arrested, and there is a process by which that arrest was carried out, and the way you were treated during that time, and whether all those rights which were due to you were adhered to, that portion, how it was done, is gone into, then it is the procedural part, the how part, which is being looked into. But if the court goes into this, that why this law at all, and whether it has a reasonable basis, whether it has a basis at all, then the court is going into the why part. So therefore, that is the substantive part. So broadly, I have tried to explain the substantive and the procedural parts of the due process. Now, going a little further from there, we come to Maneka Gandhi's case. Post-emergency and post-elections that happened thereafter, and after having lost at the hustings and being voted out of power, you all know that Maneka Gandhi happened to be the daughter-in-law of Mrs. Gandhi, and both of them had also fallen apart somewhere down the line. At that point of time, the passport authority issued a communique to Mrs. Maneka Gandhi saying this, that your passport has been impounded, and within 7 days you are required to surrender the passport. Now, when this kind of a direction came, under Section 10 of the Passport Act. Even now, all impounding takes place in Section 10. She filed a writ petition in the Supreme Court under Article 32, saying that her rights are infringed. Now, this challenge, which was placed before the Supreme Court, had 2-3 dimensions to it. The first dimension was this, that this action of the Passport Authority amounted to depriving her from traveling abroad. So when her right to travel abroad, she said, essentially was subsumed within the right of life and personal liberty. It was an aspect of life of the right to life and personal liberty when her right to travel abroad was taken away in this fashion. So the first aspect of challenge was this. The second aspect was that there was no fair procedure in the deprivation of this life and personal liberty, of this personal liberty aspect of Article 21, because not even a show cause was given to her. It was simply an order which stated that kindly impounding the passport. So to that extent, it was against the fair procedure which was contemplated in relation to Article 21. So 2-3 of these aspects on which this challenge was based, the Supreme Court had the occasion to look into it. Then in relation to that, interestingly, the Supreme Court looked into the aspects from various angles. And that is what will interest us. Because what the Supreme Court did herein was that it looked into it in this fashion, that one, by not giving her a fair opportunity, of not giving her a show cause notice or of not giving her a hearing at that point of time, she was deprived of the principles of natural justice. Principles of natural justice were not followed. They said that principles of natural justice are inbuilt and inherent in relation to this, and they were flouted. And therefore, they also said that as far as right to travel abroad was concerned, it was fundamental and an aspect of right to liberty. They equated that with personal liberty. And most importantly, thereafter, they said in this that any law which, or any executive action which essentially brings about a scenario like this, that law which deprives liberty, they said, needs to be, interestingly, they tested it with the touchstone of Article 14. On the one hand, they said that as far as Article 21 is concerned, Article 21 at the time of the Constituent Assembly debates had brought in the procedural part of due process, but due process as such was consciously avoided. This was something which they also acknowledged in the said judgment. But how do they introduce due process is what is interesting. They introduced due process by saying this, that any law which is arbitrary will be attacked by Article 14. So here was an action which they said was arbitrary and therefore would be hit by Article 14. So by 14, they said that 14 is the touchstone by which arbitrariness will be determined, and not only has that law not to be arbitrary, the law also has to be reasonable. So when they said that the law has not to be arbitrary and the law has to be reasonable, they brought in this aspect from Article 19. So they said that any law which deprives liberty, personal liberty or life, has to be fair, just, and reasonable. They came up with this three words used in one go. Now, these three words essentially are the same three words by which due process is in a way described in American jurisprudence. The same three words were used, and this fairness, which essentially spoke about the fact that it is not arbitrary, meant whereby that the law had to satisfy the test of Article 14. Because earlier, in terms of Article 14, because from Royapa, because that's why I said Royapa, because Royapa brought in this aspect by Justice Bhagwati's saying this, that any law which is arbitrary is essentially something which attacks equality. It is unequal. So they brought in this arbitrariness aspect in relation to testing Article 14 there. Earlier, the element of classification and based on an intelligible criteria was what was generally used in relation to Article 14. When you go to various judgments of Article 14 and read its development, it talks about an intelligible differentia. That intelligible differentia test, interestingly, in Royapa was not looked into, which is also one of the criticisms of Royapa, because Royapa had challenged it on that basis. Wherein he had said that when you look into various functions which are performed by chief secretaries, the chief secretaries form a class within themselves. Now, when you relegate a person from being a chief secretary and create a post wherein he does nothing, your action essentially is creating a class without an intelligible differentia. You cannot create a class like that, and that is arbitrary, is what he was saying. But here, the Supreme Court went on to a different tangent and, however, came up with this idea that arbitrariness and inequality are two facets which have to be looked into. So, using that in Maneka Gandhi, the court came to the conclusion that Article 14, through Article 14, the reasonableness and the arbitrariness of state action will be determined by the court. To determine what? To determine this as to whether the law thereafter, which is depriving liberty or life, is just, fair and reasonable. So when it is doing this, it is essentially importing the element of the substantive aspect of due process. It is employing the Y aspect out here when it looks at it from the Article 14 point of view. When it looks into any law with this, that whether it is attacked by that vice of arbitrariness or whether it is reasonable, when it is talking about those two aspects, it is bringing in the Y element. So thereby, it expanded the entire scope of Article 21. So it brought due process in a different way. Conscious of the fact that due process was avoided by the Constituent Assembly makers, it brought in due process by the way of Article 14. And this due process element which it brought in, thereafter spawned many rights, innumerable number of rights, which are not being defined anywhere in the Constitution, but the court interpreted them and brought it in through Article 21. Some 30 to 35 odd rights. To give a broad example, the latest example, right to privacy. It was never a right which was defined, but the court brought it in by way of Article 21. Like in Maneka Gandhi, right to travel abroad. So, as I said, right to die with dignity, another aspect which I had dealt with in relation to a matter which I did earlier in Aruna Shanbag's case. So, Article 21 then became the lifeblood, if you one could say, of the chapter of fundamental rights. And 14, 19, and 21 became the kind of a golden triangle. The Supreme Court thereafter said that these happen to be the golden triangle of rights. So, what did Maneka Gandhi do? Maneka Gandhi also brought a shift from what was being done in Gopalan by saying this, that fundamental rights are not to be seen in brackets. They are to be seen as a scheme in the Constitution, and each one of them flows into each other. So therefore, any law, a challenge which is placed, that law will be tested on the touchstone of all these rights in chapter 3. Essentially, these three of the golden triangle: tested in relation to 14, tested in relation to 19, and tested in relation to 21. So with this, I end this aspect today, wherein I have traced the development till Maneka Gandhi. This was the journey which we had started, and we have come to an end here. More hereafter.